Welcome to Reducing Risk, a series of podcasts from Medical Protection created specifically for clinicians in Aotearoa, New Zealand. Reducing Risk looks at key medical legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. Today we're extremely lucky to welcome back as our special guest Morag McDowell, the Health and Disability Commissioner. So welcome, Morag. We also have my colleagues Sam King and Dr. Chow-Yan Chen, who are both medical legal advisors from the Medical Protection Society, and I'm Dr. Lucy Gibbard, another one of the medical legal advisors. So we're basically picking up on our last podcast, and we're spending this time now talking about HDC processes, how clinicians interact, and we've covered in our last podcast a little bit about the actual process, and we talked about how what's good in a response and what clinicians can do to try and avoid an HDC complaint. But I'd just like to go on now and think of a new aspect of HDC cases, because in many complaints, look, something's gone wrong. There might be poor communication or a misdiagnosis or a complication of treatment. But sometimes, thankfully, rarely, there is actually a consumer who has either completely unrealistic expectations of the service, what the service can provide, and who can sometimes be quite aggressive in their complaint and whose concerns really can't be resolved with our usual approach, which is explain what happened, apologise when needed. I'm guessing that if clinicians find such consumers hard to deal with, the HDC may also find them hard to deal with. Can you just tell us a bit, do you approach cases any differently when the complainant's expectations seem to be beyond what service can offer? Is that a different approach for you, or is it?
Yeah, so firstly, thanks again for the opportunity to be here. Look, I think you said that it's rare, and I think thankfully the consumers who might be considered unreasonable, frivolous or vexatious, they really, we don't see a lot of them, but most certainly we do see complainants who have unrealistic or unreasonable expectations, both of the providers and HDC. So firstly, can I say that obviously everyone has the right to complain.
Yeah.
And so even when we perhaps think, oh yes, there's an aspect of unreasonableness here, we will still assess the complaint, because sometimes people's distress can play out in these situations, and there might actually be a kernel of truth within the context of the complaint that does need addressing. So we will still assess it. But that said, we obviously also identify those complainants that, as we've talked about, are unreasonable. I think it can often be quite helpful for the HDC to be involved in those complaints, because we can offer the independent review of the care and engage with the complainant in that context. We use guidance from the Ombudsman on managing unreasonable complainants and unreasonable complainant behaviour.
I didn't know that existed. Yeah. Is there a guidance document?
There's a guidance document. It's on the Ombudsman's website, and I can provide that to you, Lucy. It's really useful guidance, and in fact we've developed a process with an HDC when we believe that the complainant is being unreasonable or engaging in unreasonable behaviour, to firstly assess what we believe the unreasonableness to be, and then has it reached a threshold where we can put a management and a plan in place to manage the expectations of that consumer. And it might be, for example, where we say we will receive your correspondence, but we're only going to look at that correspondence once every fortnight, because we might have been receiving multiple emails a day. We don't tolerate abusive or aggressive behaviour towards our staff, and if we see if it's known that the consumer or complainant has acted inappropriately in their dealings with the provider, I think we're pretty good at saying that that's unacceptable as well, because people do need to be safe in their workplace and need to have the opportunity to deal with complaints appropriately. So, and I think we also have a pretty good antenna for those complaints that are either potentially vexatious, frivolous, or unreasonable.
That would be my experience as well, that the HDC, you seem to pick up on. I think a lot of patients make it very clear their approach and their attitude, don't they? And you manage it well, I think.
Yeah, and I think I agree with your comment that it is sometimes helpful to be involved, because a lot of our members, if they're getting repeated complaints from a patient who it's not getting resolved, and the expectations are clearly unreasonable, we do sometimes suggest to them, you have a right to complain, and you have a right to complain to the HDC or the advocate. And that actually, it reinforces that commentary that, I hear your concern and I've tried to deal with it and it's not helping, so perhaps you'd like to appeal to a neutral regulator.
Yeah.
And we definitely get to that point where we're answering multiple complaints with our members that we actually think having the HDC involved now would be very helpful.
Yeah.
And then sometimes they get sent back to the provider and we think, bother. And I wonder if, how would you feel if a provider said, please don't send it back to me, I'd like you to actually help with this? How would you respond if a provider said no to having it sent back to them?
Look, the whole point about a provider referral is to try and get resolution between the provider and the consumer. And if there's no possibility of that occurring, or that, there's factors that we may not have been aware of, for example, which make that resolution method unhelpful or not going to be able to work, then by all means, it's a contact back with the HDC to say this is not going to.
Yeah, we don't feel able to resolve this with the consumer. We'd be happy for you to go through your process and give you a response instead.
Yeah. Yep. In saying that, I think there is a threshold for doing that. You shouldn't be sending all of the provider referrals back to us.
Most providers, when it's referred back to the provider, it's so good because actually it allows you to deal directly and get things so much faster resolved. So I think it would be a very, very rare situation, wouldn't it?
It is only the ones where the patient, we've tried, and the patient's not having a bar of it. That's when we would say, please go to the HDC. Yeah. We cannot help you any further. Just along similar lines, is it possible for practices to contact the advocate and say, please, can you get involved? Because I know currently it's the consumer. Can we do that?
I reflected on this question because actually the way the advocacy service is set up and the model that they apply is really consumer-centric in the sense that they're there, and it's intended to be this way under the legislation as well. They're there to walk alongside and assist the consumer have the complaint resolved directly with the provider. I think in most circumstances, what would be useful is, and if you think the advocacy service could be of assistance, and they are great, they're as good for the consumer, I think, as they are for the provider in terms of process and having concerns clarified and expectations clarified as well, resolution needs clarified, to strongly encourage the consumer to make contact with the advocacy service, provide them the contact details, have a low threshold for saying, this service is here to help. So that is probably the better way to have the advocacy service engaged.
Yeah, I know there are definitely cases where the practices have tried to do that and tried to get the consumer to involve an advocate, and it hasn't happened. And the practices have asked us, why can't I get an advocate? But yeah, as you say, it is a consumer service, basically. But, I think it reflects the fact that practices do appreciate the advocates, help in resolving things. And sometimes actually having a third party another ear to hear what the concerns are and clarify what's going on. It is very helpful for everybody.
I think particularly for consumers who may not necessarily be health literate, for example, who may have difficulty actually enunciating what their issues actually are, can be really helpful. And of course, HDC often refers to advocacy as well. If we think a complaint would benefit from advocacy involvement, we will refer it to them.
So the other area that I think we're going to see a lot of issues around is the use of AI and AI transcription tools, which are becoming pretty ubiquitous in general practice these days. And obviously what that's going to do, because we use the clinical record when there's a complaint to look back and see what happened, and how the HDC is going to judge what the clinical record says. Do you think it's going to be a useful thing having AI transcription, or we know it makes mistakes? We've seen some pretty big mistakes already.
Yeah, so obviously we need to be receptive to the fact that, healthcare is evolving, the digital world's evolving, and we can expect to see AI come up in complaints. In particular, for example, as you say, the record, the code of rights will continue to apply to practitioners using AI or other digital tools in the same way. Providers will be held accountable for how those tools are used and the accuracy, for example, of the clinical record, because we know AI hallucinates, for example. Yeah. And it's what I'd be saying to providers who are using it, it's really important to check that it is an accurate record of the consultation. And it's your responsibility to do that and to check that accuracy. I think that it's also really important, particularly as it's evolving, to get the consent of the consumer to the use of the AI tool or other digital tool. So that if, for example, they got their clinical notes, they could also check the accuracy of it, for example. But actually knowing, and if a consumer says, well, no, actually, I'm not happy for you to use AI, then obviously it needs to be explained the consequences of that refusal as part of that conversation as well. In terms of diagnostics, because you can imagine that it's starting to get... we're starting to develop into that area. I'd just say, particularly as we're going through this evolutionary phase and there's still, as you say, mistakes being happened, clinical judgment will also need to be exercised. So it's just really important for providers to understand what their duties and responsibilities are when they're using these tools.
I just wonder how the HDC will cope when the clinical record says one thing and the provider says, oh, yeah, that's what it says, but actually that's not what, that's wrong, I didn't check it properly, and how accountable for that, it's going to be, I can see complaints coming where the clinical record doesn't necessarily...
Even now, though, there are some, where we write our own notes where we get it wrong.
Yeah, that's right.
My expectation is it would be similar to that. If it's wrong, it's wrong. And I guess the question is, 5 years down the line when the complaint was made, the credibility of going back and saying, no, that isn't what I meant.
Clinical record keeping, documentation is just so important in the sense that it's not just important for the management of complaint, because obviously we look at the clinical record, but it's really important for continuity of care for the patient. And that's probably more important in terms of ensuring that there is clinical accuracy in order for decisions about that person's healthcare to be made appropriately. I'm obviously we regularly comment on the standard of documentation in all parts of our process, not just investigations, but when we're actually closing matters as well for as not needing further action, we might comment on documentation. And of course, I also realise that pressures in the system don't help documentation either, just in terms of, the number of patients you've got to see and the number of clinical records and clinical accuracy of record keeping in that context. So that's all considered. Having an accurate clinical record or a contemporaneous clinical note undoubtedly helps in the resolution or understanding of what happened when a person raises concerns. So they can quite often be protective.
Oh, certainly. I mean, we look at a lot of clinical notes, as you can imagine, and there is variation, of course, but you're right. Documentation is really important, and it's something that we talk about a lot, don't we?
One thing I do think one of the issues is obviously with AI, notes are longer. And that actually now that everything's electronic, when I started general practice, we still had paper, and some of the old GPs, literally the whole consult will be on one line with the script at the end of the line, and that was it. And that was partly because they were seeing the same patient. They knew the patient. There was maybe more memory for them, and there wasn't so much movement of patients. But I look at now, and sometimes with a single patient, you can be scrolling this year's daily records for ages. And then actually, one of the risks when we write really good long notes is actually there's something very relevant recorded 2 years ago.
We've lost it.
And you've lost it because you can't read. And the patients often say, I expect you to read my notes before I come into the consultation. We often get that in complaint letters. And you think, there is no way that a clinician can read the notes before a patient comes in. They are so voluminous now. Is voluminous? Is that the right word? And that's a kind of a contrary risk to having very good notes that say something that's relevant and you don't read it because there's just too much to read.
Yes. To be honest, I can't recall any complaints where that issue has arisen. But that's when I'd say, well, again, that's relevant information that might be put to the HDC when you're responding to complaint of that kind. I think probably if I think about complaints that we've had involving clinical records that haven't been read, it's the situation where there's critical information in a pre-operative consultation that hasn't been read by the surgeon on the who's conducting the procedure. That is important to have looked at. But that idea that clinical notes are so long that you don't have a time to go way back, I've not encountered that. But again, I would suggest that that is relevant information that you need to put into response to the complaint.
I think in primary care it's a little different because I don't know what the patient's coming in for. You can read all of their notes if you want, but actually they'll probably come in for something different. Whereas in a hospital, when you're talking about a surgeon operating, there are definitely a set of notes that must be reviewed prior to operation that, no one's going to argue with that, right? And so I guess that's the thing. But you're right, the AI notes are long. I do Heidi, they're super long.
Yeah.
And I don't want to read them because they're so long. But it'll be interesting to see the AI space. As you say, it's fast moving. And I suspect the government will move to regulate that space. And in terms of providing guidance, and this is what you must do. And especially after the Manage My Health issue, they're going to put guidance and regulation in place so that we've got guardrails up so everyone must comply.
Well, there you go. Watch this space. See what happens. But I do think the volume of notes is so significant now. And I have had one case where there was an issue where a clinician hadn't looked 3 consults back. They'd looked at the previous consult, but there was an issue that had come two or three before, and I kind of think that's just so understandable. It could have been me, which is often how I look at complaints. It could have been me.
So, Morag, I was just going to ask you about the agreed breach. This is something new that the HDC have introduced recently. I personally think it's a really good thing. But I was wondering if you could explain to our listeners what the agreed breach is, why you're doing it, and what options clinicians have when we get that letter saying, do you agree to this breach finding?
So I mentioned before that roughly 7% of complaints get formally notified as an investigation, and our challenge currently at HDC is to manage the backlog of cases in our investigation space. We've done really well in our preliminary assessment space to eliminate the backlog. Now we're concentrating on investigations. A couple of years ago, we developed this process whereby we thought actually on the face of the information that is available to us, including, for example, an adverse event review that's being done with multiple recommendations and acceptance by the provider that essentially the quality of care was not up to an appropriate standard, is there the opportunity, therefore, to seek from the provider an agreement to a breach of the code? Now, we do this in the vast majority of cases with group providers or institutional providers. It will be Health New Zealand. To be honest, I don't have data on whether we've done it with general practices, but it's institutional providers where we go, actually, we think on the face of the information there's been a breach of, right, for one of the code. Do you agree this is the sort of factual basis that as we see it? Always offering the provider the opportunity to say, actually, we don't agree and we want you to go through your normal investigation process. That's absolutely fine. We will do that if there's no agreement. So we saw it as a way of firstly managing some of the older files that we had on hand, but also it's a way to speed up the process for people, so addressing delay, and of course, as I said, those quality improvement measures, the recommendations that can be made to ensure that risk is mitigated for the future.
So if there's an agreed breach, that means that generally you won't be getting an expert opinion and going through that investigation process, is that right? Often those files that are sitting within investigations have already gathered quite a lot of information. There may, in fact, be an expert opinion on file. But that said, I know the reason why I've focused on adverse event reports is because that's where there's been most comment about the agreed breach, of actually using adverse event reports as potentially the basis for an agreed breach. Of course, in the context of adverse event reports, there's often been expert input into those that can help us. But we will also have often had a response from the provider as well, where there's been an acceptance that the standard of care was not reached.
I think those are the ones that I'm familiar with, and I think it makes a big difference to not go through a formal investigation because, one, it takes a long time, it's hugely stressful, and usually when an investigation takes place, the medical council are notified, and I think in many of the cases that I've seen, the member thinks, actually, let's do this. It's true. I admit that I made this error. I've made all these changes to my practice, etc., and we can move on. And it means that the consumer can move on. It means that the provider can move on.
And do you advise the provider of the consequences of accepting that agreed breach? For example, if you were intending...
The recommendations that she's...
right. So they go out at the same time.
Yes, that's one point I want to make. The HDC does not make recommendations in any situation, without providing the providers the opportunity to comment on the recommendations. Because actually we want to hear if a provider thinks that they're wholly unrealistic and they're unworkable. Well, it's pointless making a recommendation if it's not useful, if it doesn't address the issue to which it is directed. So I make a hearty plea to all the providers who are on the receiving end of a provisional opinion or provisional recommendation to provide the response to it, because we will modify the recommendation if it's not going to be useful.
I think one thing about agreed breaches is that adverse event report. And I think from our point of view, some of them are done well, but it's not infrequent that adverse event or significant event report has been generated through an administrative system that's had some input from some clinicians. I mean, I have definitely had cases where the clinician involved in the case had no idea that it had even happened, hadn't been informed that it was happening, and then later when it became an HDC case suddenly saw this report that they'd never seen before. And so I think I can understand why the HDC use them, because you would think that if the hospital have gone through a process, they might have involved the clinicians who were in the case and experts, and that report might have had the input that it needed. But isn't always the case. So I would actually make a plea for our listeners out there that if there is a significant event, you actually turn around to the hospital and say, are you writing a significant event? Can I see it? Can I be involved? And actually you get involved and you make sure that report is accurate, because it's really difficult to come back 6 months later when that report has been finalised by the hospital and you haven't seen it, and then it's at the HDC and the clinician says, but that's wrong and that didn't happen, and it's taken as read. So I think the fact that the agreed breach system is there, it kind of highlights how important it is for those internal processes to be correct and for clinicians to engage in them, because I think sometimes it's the clinician says, oh no, it's all right, you write it, which I think is not a good approach. I think the clinician should say, yes, I want to be involved in this. And also see the draft.
I would agree that sometimes some of the clinicians have said to me, oh, they told me it would be fine. And I don't need to worry about it.
I don't need to read it.
I didn't need to read it. I didn't need to worry about it. And, our members, if you call us early, we will walk you through that process to make sure that your interests are protected. And I agree
and that they're accurate.
And
they're
accurate.
Correct. Because it needs to be for the patient, for everybody. If it's been done without the involvement of the clinicians or only with very superficial involvement from a head of department who wasn't actually there, they aren't useful.
They're not.
And then you get to the HDC and you think, please don't rely on that. But anyway, as you say, you're going to be asking. It's not it's an agreed thing.
If a provider said to you, actually that adverse report is based on the wrong facts, would you look at that?
Look, I completely agree that there's huge variation in the quality of the adverse event reports that we see, often associated too with geographical location as well. I really want to emphasise that this agreed breach process is really used for the group and institutional providers. It's not used for individuals. And I also want to emphasise that getting adverse event reports is something HDC has always done. Mm. It's a relevant piece of evidence because, aside from anything, it helps us formulate recommendations or identify if recommendations need to be made. It really worries me to hear you say that clinicians are not involved in adverse event reports.
Sometimes, not always.
Sometimes, well, in the sense that the whole point of these reviews is to learn, and they need to be factually correct in order to learn. The other issue that I've had is the lack of involvement of consumers and their families in adverse event reviews, because their perspective is absolutely relevant to the learning exercise that is mandated by the process of adverse event reviewing. I would say we're pretty astute on assessing the quality of the reports. Some are really very, very good and align with the clinical record and other information that we have. But I saw one the other day where I realised there was a factual inaccuracy in the report, but I was able to conclude the fact because I had evidence of it.
Right.
From somewhere else.
Yeah.
So, yeah.
Mm. Yes, but I think it's a plea to our listeners and to our members that to get involved in those reviews, in those significant event reviews, and to try and make sure you see the draft documents before they're finalised and make sure they're accurate, because they might go elsewhere. And talking about things that go elsewhere, one issue that comes up quite frequently for clinicians and also for our patients and consumers is how complaints can move between different parts of the regulatory system and different agencies, and so that one single concern may be referred to the HDC and the Medical Council and ACC and the coroner, and often it's in parallel, but it can be sequential. And from the outside, it can feel like the responsibility is being handed on, and in some cases, the underlying issue can take years to reach resolution. And that can be exhausting and demoralising for the consumer, but also very distressing and frustrating for the clinician who wants to see a resolution. I don't know if you've got any thoughts about that and about the way agencies work together.
This is certainly not a new thing. I remember 20 odd years ago when I was Director of Proceedings, that was most certainly the talk at the time, the multiple agencies that can be involved in a single event or reviewing a single event. I think it's really important to understand that different agencies have different roles. So actually it's entirely appropriate for ACC to be doing its assessment of the care, because actually that will lead potentially to compensation and support for the consumer in the context of a treatment injury. So whereas HDC's focus is very different, obviously we're looking at the code and the extent to which rights have been adhered to or not. HDC has over the last couple of years gone through a process of refreshing all our memoranda of understanding with different agencies. We've got one that we're currently working on with the Coronial Service, Chief Coroner, because of course you want to make sure that there is a good interface between the agencies in terms of which agency has responsibility for looking at the issue. If I take the coronial example, the Memorandum of Understanding identifies that when there are, say for example, we might have received a complaint or indeed a referral from the coroner's office, there's a discussion that happens to identify who goes first. Now, if it's the case of a suspected self-inflicted death, it will be the coroner's process that takes precedence over the HDC process. And it has a former coroner. If the HDC had done its work and I then received the HDC report, I would often then just close my file because I was satisfied that the cause and circumstances of death had been adequately established through that process. So the Act actually allows that to happen. Likewise, if I receive a report from a coroner and I'm satisfied that the adequacy of the care and episode of, provision of health service has been looked at adequately, I can close as well. I have been quite thoughtful about concurrent processes. We've done it on a few occasions. If you take, for example, medical counsel, and again, it's the way the legislation works. You have to notify, and vice versa, in certain circumstances. Each other, so the regulatory authorities and HDC. I've had a case where you look at it and you go, well, actually the medical counsel is best placed to manage the individual provider, but actually they can't look at the system. We should look at the systems issues that were raised in this case. In terms, again, the coroner, it's sometimes really hard to run concurrent processes because you don't want to prejudice each other's inquiries. And that in and of itself can be burdensome, I think, for providers and consumers as well. So I think it's difficult, but we're trying to make it as seamless as we can. But I completely agree with you. If you have sequential processes, it can be drawn out and drawn out and drawn out. And I think that's where it's where we as HDC or the coroners or regulatory authorities really need to think, what is an appropriate process for us to take at this point.
Yeah, and I think if the processes were faster, and it sounds like we are getting resolute, one of the problems was if the coroner was saying, well, I'm waiting for the HDC, and then the HDC took 2 years, and then the coroner starts, it actually made it extremely long, and you'd get to 5 years and you'd think, oh gosh, what happened?
Yeah, I think that's also about agencies communicating well to the participants in the process and setting expectations, because actually, and I agree that, you have those situations where somebody says, one agency says, oh, I'm waiting on the HDC, or HDC, we're waiting on the coroner. Yeah. But that doesn't necessarily then mean that there'll be an added 3 years on for our process currently. Actually, I think we get it, and we would make a decision about whether there's any further merit in looking at the process further. I can't speak for the coroners now, of course, but as I said, when I was the coroner, if I was satisfied that the cause and circumstance of death had been met, I would close the file. The jurisdiction allows that.
I do know that for the medical council, if they do wait for the HDC outcome, often at that point and let's just say the doctor wasn't breached, that they would take that as reassurance, and often they don't take a long process. So that can be really positive, but we do have some members who are running concurrent HDC medical council processes, which I'm not sure how any doctor survives through all of that, to be honest, but unfortunately we have to be accountable for the care we provide, and there it is.
It's actually reminded me, you talking about the waiting for one process to go to another is actually letting clinicians know where things are at from the HDC point of view. I don't know, because I know we've talked about it in the past sometimes, if there was a way of telling doctors we are still looking at this, or is there any kind of recall system in your computer system or any way of telling people what's going on, or letting the consumers know?
I would really hope that we've improved on our communication because I knew it was a particular issue. I'm very happy to report that hopefully by the end of March we will have a new case management system in place, replacing our Lotus Notes-based system. So we're feeling very excited about that. And my expectation of that system is that that'll be easier, I think, to communicate with participants to the process, including providers. I think there probably is still more work to be done within HDC about that. I think we have improved, though. For example, all our investigation files are allocated to investigators, and they do use their diaries for call-ups and ensuring that communication. It became very difficult, I think, during that period of huge volume to be communicating in a meaningful way as well, because it's just like, it's still with us,
Yeah.
We were getting those letters at least to say it's still happening. We're still looking at it.
I have one member who used to ring me every 3 months. So do you think it's still? Do you think they finished it? And it was like every 3 months have gone, and it was still going on. And he'd ring me back. Do you think I should ring them? It's like, no, I think it's just. So it would be great if there was a system to tell clinicians, even if it is just an automated email, to say, look, we are still looking at this. Please bear with us. Let us know if you've got any concerns. That would be nice. Anyway, thank you so much, Morag. It's been really fantastic talking to you and learning a bit more about how the HDC worked. I'm interested in that ombudsman thing on dealing with people who may be difficult to deal with. I'm going to go and look at that. So thank you very much for coming, and thank you, Sam and Chow-Yun, for being here as well. And thank you to our listeners for listening to this podcast, and I hope it's been helpful. We look forward to catching up with you in our next podcast. If you like the Medical Protection Podcast, please subscribe and leave a review. If you would like a podcast on a specific topic, please email us on nzpodcasts@medicalprotection.org. So thank you, everybody.
Thank you.
Thank you.